Hey, good afternoon. What's up with us fans? We're going to get started in just a minute. It's not quite 12 o'clock. We'll let some more of you join, and Michael and I will give you our newest case law update. Thanks for joining us. All right, good afternoon, everybody. Hi, my name is Neil Kalin, and I am joined as always by Michael Simkin, and we're going to talk to you today about four cases that may affect your real property practice, or they're good to know if you're a real property lawyer. So this is What's Up with Us. It is a monthly, I like to call a podcast style webinar session that we do where we talk about recent cases in California. And let's see what's in our agenda today. Here's our agenda. What's up with us? And no, nothing special in the "What's Up with Us" bullet there, except I am going to make an announcement. We always try to make "What's Up with Us" A, relevant to you, our listeners, and B, we try to give you value, which is why for this year, was it this year? Yeah, this year we started, or last year. I don't remember when we started giving MCLE credit, but we're giving 1 hour of MCLE credit for listeners to the What's Up with Us. And starting next month, we're going to start doing something special as well. We're going to be able to give away a special code so that one listener will be able to access a 1 hour MCLE that is in the Real Property Library on the CLA website. So stay tuned next month. We'll announce a little bit more about that, but always trying to give you value when you join us on What's Up with Us. So today we're going to talk about four cases where we don't have an interviewee this month. So instead of that, we're talking about Michael Simkin is going to give his Simkin secrets about how to impress a court. So I really like that, Michael. So we're going to talk about Bata versus Hunt, which is an easement case, and it goes into more than just pure easement issues. And I know Michael likes to talk about those extra issues. So Michael's going to take the lead on Bata. We're going to talk about Bottega versus National Surety, which is one of these insurance smoke damage cases. You see, this is a federal case, it's a district court case. And I actually heard about this case when I was at a seminar, and people were talking about this case as if this was the brand new law in all of California, completely ignoring the fact the case that we talked about last month, which was the California Court of Appeal case, Garibian versus Wawanesa Insurance, and little distinctions there. And we know California Court of Appeal cases, they are binding on all trial courts in California. A Northern District federal case, is that binding in all courts in California? I don't think so. Maybe federal courts in that district, but it's worth talking about, and it's a good distinction of what we talked about last month with the Caribbean case. Then we got Michael Simkin secrets. We're going to talk about Ohio House and sober facilities and whether it's discriminatory to limit the number that can be in a particular area, zoning area. And then we're going to end up with Schneider versus Lane, another easement case, but going with a different aspect. What duties does the dominant tenant holder have regarding maintenance of that? And we're going to end, as always, with our upcoming activities, events, and education. So let's jump right in. That was probably my shortest introduction ever, Michael. Do you have something you want to add?
No, I don't. I think you covered it. I mean, come on.
All right,
We
great. So
can
I'm
talk
going to
about
turn
a
it
lot of
over.
stuff today. I mean, especially
Yeah,
you
there
got
is a lot
like
of stuff today.
I mean, you got like one 300-page opinion, I think. It was like crazy. Anyway, um,
Well, yes, a very long opinion. Most of it was unpublished, right? So when we get to that, you're going to have to read these cases carefully. Make sure you're not wasting your time on the unpublished portions. Go ahead, Michael. Why don't you start with Bada versus Hunt, and I'll just jump in as I feel is necessary. How's that?
yeah, you can jump in and correct me because I do defer to you on things. All right, this
Oh,
bot.
wait, but before you start, Michael, before you start, I don't want to interrupt you in mid-thought, right? So, just a reminder for the audience today that if you have a question or a comment, please put it in the chat. Michael and I will be looking at the chat periodically, hopefully in enough time to respond, publicly to your question or comment or insight. So that's it, Michael. Take it away.
Please do the chat because we want to. If we have something that we didn't cover or you have a question, we want to collectively use our, 1.5 brains, I'm the half, and try to figure it out for you. All right, Bata versus Hunt. So I kind of like this case, but for different reasons than you may obviously think. So Bata versus Hunt is also another one of those cases where I'm not super surprised. I happen to know the judge and um, the defense lawyer in it, at least. And so it's kind of interesting. And it's a kind of a case where the trial court tried to split the baby, I think, but then the appellate court was being kind of let's follow the rules very objectively. And I don't know if that's good in the big picture, but here's what happened. So this is a case where there are two adjoining property owners. And these two adjoining property owners, um, the way the relationship started is I think about 25 years before the lawsuit was filed. The plaintiff, Bata, purchased a small apartment building from another person, Hunt, who happened to own that building and the adjacent building. And there are some shared parking spaces, some shared spaces to put the trash dumpster, and everybody seemed to live happily ever after for about 25 years. And then apparently the city needed Bata, the plaintiff, to acknowledge that they had sufficient parking. And so they thought that they had sufficient parking and they just wanted some confirmation, I guess, from their neighbor who was the seller. And something happened and they couldn't get that written consent that the city wanted about the parking and the location of the trash dumpsters. Um, so my first commentary before we get into it is I would say 90% of all civil litigation that's real estate or business related is from a failure to communicate or a long harbored resentment between the parties. Okay. It's not something that, it's like something that just makes no sense, except it's going to make money for lawyers. Okay. And a lot of aggravation for everybody. Anyway, back to the story. So this is about easements. And the trial judge, who I think is pretty good, um, was a very good plaintiff, medical malpractice lawyer for a long time. And I think she tried to use some common sense here and split the baby, but as we see, that's not how it necessarily works out. So what happened here was the plaintiff filed a lawsuit trying to confirm these easements. And while you're allowed to have multiple legal theories. You can plead multiple legal theories. And the appellate court even discussed how you can allege anything you want and let the trial judge figure out which legal theory applies to the facts. That's okay, but at some point, if they're contradictory, it's going to lead to some problems. So we had implied easements, we had a prescriptive easement, and we had an oral agreement. All these different types of easements alleged. How did these easements pop up? Well, they popped up in a number of different ways. They popped up from most factually, they popped up because the two properties had a common owner, and that's a common way to get some implied easements, okay? But in this case, we had some evidence that these parking spaces in the trash dumpster easement were allowed by an oral agreement. And we know that oral agreements don't live very nicely with prescriptive easements. And so the judge had to figure out, is this oral agreement? Well, that's consent. So then you can't have a prescriptive easement. Then we have another theory that popped up. Was it an implied easement, which is basically something by necessity? Okay, because that's where they needed to have the parking spaces. And they talked about how this is seems to be a 9-unit building, but with 8 units allocated, but it really should have 9, so they should share a parking space and all this stuff going back and forth. Okay. Well, they had another theory that popped up, which is this implied theory. And we'll see in a minute that the appellate court is kind of upset that the defense didn't have a right to really prepare for that theory. So we have this whole issue about whether or not there's which theory to use. We had a trial judge looking at between 1977 and 1994 when the defendant sold the property, that they use all the parking spaces and the area for the dumpster collectively, which kind of makes sense. Then the trial judge was looking at, well, after they sold the one building, everything kept on, the same use. Trial court then did some interesting things. They looked at something called the transfer disclosure statement. So as we know, the California Association of Realty has various forms. One of the disclosure forms is mandated under the disclosure law, and that's important to remember, it's under the disclosure law, is the transfer disclosure statement, also known as the TDS. Well, guess what? The seller described in its transfer disclosure statement that there is an easement. Sounds perfectly normal. Sounds like there's no fighting. It's like, yeah, there's an easement. You can use a parking space and an area for a dumpster, no problem. Like in this case, it was, I think, for 2 parking spaces on the for the Bata property and a space for the dumpster. Well, this is where you have an issue. The defense said the transfer disclosure statement should be treated as a secondary document because there's no integration clause that it's integrated into the real estate purchase agreement. And this led to an issue with parole evidence where the TDS was excluded. Now, I'm going to jump ahead a little bit and continue with that line of thought, and because I know Neil is really interested in this. It is common that these disclosure statements are something completely different. It's very common when I have a failure to disclose case that the seller property questionnaire and the transfer disclosure statement, they're independent. And you can't say that's part of the contract and there's a breach of the contract, which is the real estate purchase agreement, because they're not integrated into that. This case went really clearly, and they said parole evidence rule, and that's parole with the E, won't apply to bring it in. You can't bring it in as a contract theory, okay? Just can't do it. So that's going to be useful for other issues for defense lawyers in these failure to disclose cases. The big problem the appellate court had was all these inconsistent theories. So let's go back a step. One of the theories was prescriptive easement. And so the court kind of found that there was no consent to use this extra space by the plaintiff. Well, that could be prescriptive easement, but isn't that rebutted by the transfer disclosure statement that kind of says you guys can use the space? And it kind of is rebutted by the other issues, which is they said there was an oral agreement to use the space. And this is something that comes up really commonly. Whenever I see a case and someone's alleging a prescriptive easement, if I'm the defense lawyer, I just got to figure out, was there ever any sort of agreement to allow that to be used, or knowledge that it was used and nobody did anything about it? Yeah, I can work with both of those. So prescriptive easement is really tough, meaning impossible, if you can show that someone gave consent. This comes up with fence cases and everything. Okay, it's crazy. It comes up with driveways. There's a lot of properties where, for example, and I've had this before in West Hollywood, there are buildings that were built in the teens and the 20s, and the driveway along the side is very narrow. And the cars, when they drive down this driveway, kind of hang over. And people want to then 100 years later say, you can't drive there because when you drive there, you're driving on my property 10 inches, and that's a prescriptive easement. It might become implied easement, but it's usually not prescriptive. And usually you can find someone to say, oh, I didn't mind. I told them it's okay to do that or drive on that, or someone decorated something. So be careful about that. Anyway, back to the case. This Botha case was pretty good. They give a nice little analysis about alternative legal theories. It's completely fine, but after the inconsistent or alternative legal theories are presented, the burden is on the judge to decide if the facts fit into any of those alternative theories and decide what should be presented to the judge or the jury. Okay? Now, here's what the appellate court did. They looked at this and they said, we have irreconcilable contradictory findings, so the judgment has to be reversed. That's the example of having a prescriptive easement coupled with a verbal agreement to, say, use the parking space, something like that. The oral easement, it can be enforced, but again, an oral agreement needs to have some support, okay? Now, the court made it really clear about the TDS disclosure cannot be used to show as oral evidence of this oral easement. They said, nope, okay? And if you look at the real estate purchase agreement, it says this is a full and complete document. You'll see that, which is the basic law about a complete and final embodiment of the terms of an agreement. Then you cannot use oral evidence to add or vary its terms. So that is the essence of why the defense was successful. Now, this is some of the other interesting parts. What happens? The court, sends it back to the trial court to make some findings consistent with what they did. And I don't know what happened on remand. I'm going to guess that on remand, they dropped the prescriptive easement claim and they just went with the implied easement. That's what I think they probably did. And they allowed discovery because the appellate court was kind of upset that this last minute implied easement was like jammed down the defense's throat. And so that's what I think happened. But like I said, what I think this case stands for is that TDS clearly cannot be used for anything else other than your required Civil Code 1102 disclosures. What do you think, Neil?
Well, so that leads me to, there was three things that I was thinking about this case. I'll start with the one you're talking about. So in the CAR purchase agreement, there is a contractual requirement to provide the TDS, but that contractual requirement is in the disclosure paragraph. So it's not making the TDS a part of the contractual terms that the buyer and seller are agreeing to. It's just saying you will comply with making these disclosures. So in my view, the purchase agreement is not changing the character of the TDS from a disclosure into a contractual document. It's just saying this disclosure document shall be provided. So that's one. Second thing is, I have heard from attorneys over the years who said they do not recommend that a seller provide a transfer disclosure statement, a TDS, unless it is legally required. And I was always thinking, what's wrong with extra disclosure? Disclosure is a good thing. So if you have a probate sale, or you have a trust sale, where the trustee is not living in the property, for example, and you say, well, why not give them some kind of document to make an extra disclosure, even if it's not required? And to me, this case actually gives a good reason why you would not want to make an extra disclosure where one is not required. This was the sale of 8 units. A TDS is only required on the sale of residential property with 1 to 4 units. So a TDS was not required in the sale of this property. The seller chose to use the TDS anyway to make some additional disclosures, and those additional disclosures wound up creating a problem. So this has given me cause to rethink the advice that I've heard from other attorneys about, wow, this may be a good reason why you would not want to use a TDS when one is not legally mandated for the sale. And I haven't completely come around to that position, but at least it's given me reason to understand the thinking of some of the attorneys who have said that to me over the years. The third thing I wanted to say was I happened to look up this property. Why? Because it's not far from where I live, and I was just kind of curious what it was. And there was a really great you can get a great photo through Google Maps of what this property looked like. And when you see it, I have to admit, I don't understand why photos are not used more in published opinions, because you really get a grasp of what this property looks like, where that shared driveway is, where the 4 parking spaces were behind one of the units, where the extra parking spaces should have been on the Hunt property, where the garbage receptacle should have been. So to me, I would like to see courts in the future use more pictures or graphics, because it's really hard when you're just getting a description. This is running north, this is running east and west, this is behind, this is in the front. You can just see it all with the graphic, and those graphics are so easily obtainable now and so easy to put into opinion. I would just like to see them done more. Those are my three insights into this opinion. So,
Yeah, but I just don't understand why this case was even litigated, because it seems that the seller of the property, the neighbor Hunt, um, knew that this extra parking space and the space for the dumpster is something necessary, and it didn't interfere with anything else as far as I can tell. Like, why incur the cost and the aggravation of a lawsuit and an appeal over this? This is what I just don't
well,
understand.
yeah, I think it goes to one of your earlier comments, Michael, which is maybe there was some other kind of resentment between the seller and the buyer over the course of this
Ah,
period of time
but
that
guess what?
said,
But Neil, in the opinion, even said at some point the defendant Hunt was, I think, ill and couldn't testify or something like that. See, that's the thing.
right?
People forget about life. There is so much more to life than these lawsuits and money, okay? And so when the Hunt guy got sick and he couldn't testify in court or whatever, this stuff, people don't realize that. Um, Something else about the disclosure I wanted to mention that comes up, I see it. It's about trustees. So, there's another set of laws about disclosures when you're a trustee that never like occupied the property, right, Neil?
Well, right. So there's a basically the general rule is trusts are exempt from the disclosure rule. However, certain trustees are not exempt. So if they occupy the property, or they were the trustor who lived in the property and then transferred the property into trust. So not all trusts are actually exempt from providing a TDS.
So here's the issue that comes up every so often. You have a successor trustee. It could be a child that never lived in the house or a professional trustee, whatever. And so maybe they don't have to use these disclosures, but what if they have actual knowledge of a defect or some problem with the property? What's their obligation then?
Well, the anyone with actual knowledge has a actual duty to make that disclosure. I'll tell you the answer that CAI was provided. We have a form called the exempt seller disclosure. And on the exempt seller disclosure, there's certain things that have to be disclosed, whether you need to provide a TDS or not. and then there's a general question, any other material fact. And that's where
Yeah.
somebody with specific knowledge would provide that
So then you
information.
get back to what you're concerned about in the beginning, which is over disclosure. Should you disclose and lead to a lawsuit? So that gets to the point that you probably should kind of disclose everything that you have any knowledge about just to avoid the issue.
Yes, you do. And I don't have the site. There was a case, it's an older case now, it's probably 20 plus years old, and I believe it was called Carudis versus Home Fed Bank. And that case stands for the proposition that even a bank, a lender that's exempt from the TDS, has to disclose what they actually know, right? So they do not have to do so on the TDS, but they would have to do so in some other manner. Michael, I think we got to skip
All right.
ahead because we spent a lot of time on this case. Okay, all right.
Well, you even looked up to see what it looked like. So why don't you take the next one?
Okay, so the next one, Bottega versus National Surety, and this is a case. It's an insurance case. It deals with fires. It deals with smoke damage. We talked about a case last month, Garibian versus Wawanisa, where the court said, yeah, hey, smoke damage, if it can be easily be cleaned, uh, we're not going to hold the insurer responsible for that because there was no physical loss or damage to the property itself. Well, here we have this federal case, Northern District of California. Again, this is a trial court case. It's a slip opinion. I don't know if that makes any difference in terms of whether it is precedent setting or not. But here's what happened, right? We're talking about the fires that happened, almost 10 years ago, 8 years ago in Northern California. There was a restaurant in Yountville, right? A lot of restaurants up there in wine country. And the day after the governor proclaimed the state of emergency, the restaurant closed down. Right? It wound up reopening the next day and then periodically closed and then reopened over the next several months. Well, eventually the the restaurant owner filed a claim with their insurance carrier for over $100,000, or filed a claim, and then the insurance carrier actually paid out over $100,000 under a civil authority claim, but denied coverage under the direct physical loss or damage claim. Both parties filed for a motion for summary judgment. Again, this case is not up on appeal. And what happened at the trial court? Well, they said, you know what? We've got conflicting evidence as to why the restaurant closed down on October 9th. And they were really focused on that one date as opposed to future dates when the restaurant was closed down. And they said, you know what, that requires a factual determination as to why they closed down. Did they close down because of the smoke damage? Or did the restaurant close down because they couldn't get workers to show up? This was the day after the state of emergency. Even though the property was not damaged by fire itself, they were so close. It was, the air quality was not good. Those of you who have been in Southern California recently understand you don't have to have your property burned to understand that there are other issues associated with fire. Maybe the roads were closed. Maybe that's why the restaurant closed down on the 9th, right? Maybe they were worried about the executive order. There could have been all sorts of reasons. There wasn't sufficient evidence to establish what the reason was for the closure. And so the court said, we are not going to grant summary judgment on that issue. Now, some interesting parts of this Bottega case was, in addition to the restaurant owner filing the claim, there are also claims by the management company for the restaurant. And we see you could look in the last paragraph on the slide today, and you'll see the court actually was able to dismiss those claims because the management company stayed in business. The management company was managing more than just the Bottega restaurant in Yountville, California. And they were still open. They were still doing business. They still went to the same location. The location was in the same location as the Yountville restaurant, but the management company was still there because they had other properties that they were managing, and somehow they were able to do their activity from that location. And the court says, just because the restaurant closes, that does not mean that the management company suffered or was damaged as a result. Even if there were smoke damage that would justify the restaurant closing, we cannot say that the same holds true for the management company, especially given that the management company returned to work and was doing business on the next day. So, in my view, a couple of things here, right? One, the court noted that 2 years after the fire, there was still a smell of smoke in the property. So one would think that, maybe you could look at the facts in this Bottega case and distinguish that from the Caribbean case that we talked about last month, which again, that was a state of California Court of Appeal case that we talked about last month, and say, there might be reasons why there actually is physical loss or damage when you have a record. And I know, Michael, you're really big on a record, where you have a record that shows that there is something, that this was more than a matter of taking a wet cloth and wiping away the soot and the smoke and the dirt and whatever toxic chemicals one is alleging is in the property. And we've got a big concern about that now, at least in Southern California, because the fire was so intense and there was so much property that was destroyed, that the argument is, and you've got hygienists, industrial hygienists, who are establishing that there is toxic chemicals as well. So you're going to have to look at the facts carefully and decide which one of these cases might be applicable. Michael?
Well, I'm glad that this case came out. I mean, I think it helps people that have like the smoke damage and everything like that. Um, and it had that
Yeah,
nice,
and we're
I think it helps, and I don't see anything wrong with it. I think, like you said, that management company, they were still doing their business, so that one didn't make any sense. But it in a very concise way, it talked about what's a necessary suspension, complete cessation of insurance business. It talked about physical loss, um, and and saying that you could have those noxious substances and odors, making it uninhabitable, unable to be used as intended. So I think this is going to be a very useful case for people.
I think so too. The one problem I have with this case is this is a federal case. It came out of an arm of the Ninth Circuit, and they completely ignored the California Supreme Court case of last year, Another Planet, that addressed damage to property and smoke damage to property, and they completely pretended. I don't know if nobody brought it to their attention, or if their law clerks didn't find it, or if the Another Planet case just did not coincide with the direction that this court was going. But the fact that the Another Planet was not even mentioned in this case, I found very surprising. And
Yeah.
even though Another Planet was a California Supreme Court case, it was referred to the California Supreme Court by the Ninth Circuit. So that kind of surprised me, that the case was just completely ignored by Bottega.
Yeah, I just
All
want,
right, Michael. Well,
that's a
now
good
we're
point. I
going
wonder about
on.
that. All right.
Yeah.
Go ahead.
Well, we're going to move on to your specialty, and we're going to talk about Simkin secrets. And here you're going to tell us all how to impress the court. Now, everyone knows I am not a litigator, so I'm very interested in hearing about this. The only time I ever have to impress a court is when CAR is involved as an amicus at a court of appeal or a Supreme Court stage. And so, but impressing a court with a brief is very different from impressing a court in person. So tell us your thoughts on this.
All right. So this is a mini class on everything you need to know to be a in-court litigator, basically. Okay. So each one of these points can be extrapolated upon ad infinitum, but I'm going to start off with the most important thing. You have to consider your audience, and there is a difference between a judicial officer and having a jury. The judicial officers, you have to figure out what they're all about. okay? And um, and it's pretty easy to figure out what a judicial officer does after you've done a couple trials. So I'm going to start off with, before I get into my list, I think the primary job of a judicial officer is to determine who's the liar. Because what happens is everybody lies. That's just the facts. Okay. Maybe it's not a lie. Maybe it's what they really believe because they've told themselves the same thing a million times over 20 years. But or people have a different view or opinion. There's a lot of psychology involved, but people tend to look at things in one direction, and that's why they always tell you when you're writing an essay or an article in school or a brief, and if you're a lawyer, give it to someone else to look over because you don't want to be like drinking your own Kool-Aid, right? I mean, when you write something, you don't see the problems. When you think about something and you present for the first time to someone looking at it fresh, they may just zero in on something that you just overlooked. Okay? So think about that. So here's what you have to do. You
So
have to,
Michael, that your advice takes me back to a somewhat older TV show called House, where House was a doctor, and one of his famous lines was, "Every patient lies." And I think you're saying the same thing about
yeah.
witnesses in a case.
I mean, it's how it is. The thing is, you have to be honest. First of all, I tell people it's hard to remember a lie. It's much easier to remember reality and the time frame associated. That's the bottom line. And if you trust a lawyer can spin anything. So even if there's something bad that you did, if a lawyer looks at it for the first time, I'd say, you know what, there's a reason you did that, and there's a reason someone else did something, you can spin it. But let's get back to what you do in court. So I started off that more than a mouthpiece, and you have one chance to make a first impression. Well, that's a generality in life, right? I see people go to court, and I've seen this multiple times, and they're like bullies. They just start right off with accusations and these ad hominem attacks. Judges hate that because it just what wastes time and it's never on point. Judges try to be very um, focused upon the framework of the law and do these facts fit into that framework, or should they put on their equity hat and do something? Okay, so you have to be very objective and present things. Okay, don't be the bully. All right. Okay, now we have some communication skills. While they've had telephonic appearances for a while, you usually only do that for like a status conference. You can't do that if you want to be persuasive. So I have actually written some articles about language and persuasive communication. Um, they're in our e-news reports. So one of the things that the real property section does is we have an e-news that comes out monthly. And I did a series of about, I don't know, maybe 5 or 6 articles that helped with how to present your case in words to have persuasive writing. And these are published, they're on the CLA website in the real property law section. You can find the e-news. So now you're in court. Don't do the telephonic communication on the telephone, even if that's an option. I suggest showing your face. So while you can, show your face on the video or not, show your face. And the basic reason is, and I've heard judges say this all the time, you can communicate much more effectively showing when someone looks at your eyes, even though it's kind of dark here, you can't really see mine. Um, you can gesticulate, whatever you want to do. Do it by video. People are humans. Humans like to look at your eyes. They pick up cues from your facial expressions. Okay, they look at what you're wearing. They look at your background. So you can do a fake background, is fine, but you have to look professional and you communicate much better if the judge can see your face. Okay?
So Michael, a point on that is if you're doing these presentations via Zoom or some other, kind of remote software, you always want to have the light in front of you rather than behind you. But of course, if you don't trust your witness, you're going to tell the witness to have the light in back of them so that their face is all dark like yours is right
Yeah.
now, Mike.
Okay, thank you. So so there's a joke. How do you know when a lawyer is lying? His lips are moving. You can't even see my lips moving, right?
We're going, right.
Anyway, I gotta work on this lighting here. It's perfectly good here. I'll work on that. Anyway, when you go to court dressed professionally, that's like a given, but I actually know one lawyer who actually is a wonderful person. She's just a very nice lady. And I remember once she showed up in this black leather outfit. I thought, okay. Once I showed up, I had to show up for a criminal hearing, and I did it to cover someone. And I said, look, I can't go. I'm like out. I'm wearing like literally like I think a leather jacket or something. And I like, okay, I'll just do it. And I showed up. The judge made some comment. I forgot what it was now, but it worked out. It's criminal law, right? But you have to like dress professionally. Okay, be on time. Um, video, you're going to be on time, I would think. But unless you have a technological problem, so make sure your technology is working, especially after an update. Your video may not work or your audio won't work. I've had that and it freaks you out. But you have to be on time. Um, a lot of courts may not start exactly at 8:30, exactly at 1:30, whenever it is, but judges hate late deterrence. It holds up everything. It's not just one person holding up like a group of like six or more people. Okay, back to the video thing. Always have, I mean, my style is to be happy, be smile. Maybe I smile too much, I laugh too much. That's how I am. Okay, be friendly to people. Okay, I have seen lawyers treat courtroom staff as their servant. Okay, they hate it. Oh, could you run off a copy for me? Well, you better be really best buddies with that courtroom assistant before you ask them to run off a copy for you. I just see a lot of stuff. Do you mind if I keep these 16 boxes here? No, don't keep your 16 boxes there. Don't treat them like your servant. Okay. Um, Going back to moot court, you gotta follow these rules. So the one thing that I always cringe when I see this is when lawyers address the court as judge. Okay, as I see judge, da 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 da. They don't want, just don't do that. You call him your honor if you want to do it like that. Or you say, I really want the court to focus their attention to this case of Jones versus Jones. Okay, just don't call him judge. It's just so unprofessional. Or maybe I'm old-fashioned. All right, there's another thing that I do all the time. I've always done that. It's visual aids. If you do a trial, you're going to use visual aids. You're going to have a poster or something to hang up. But if you are doing even a bench trial, I'm giving away my secret. But say it's a demur hearing. In a demur, the, the judge may say, well, I'm sorry, where does it allege that? You hold up the complaint. I wonder if this is going to work. You hold up that complaint and you say, here, paragraph 14. This happens to be my Super Lawyer magazine. I'm a super lawyer. Anyway, you say, paragraph 14. This is where it says whatever. This is a judicial admission. Okay? Hold things up like that. Just do it. Believe me. Maybe not on the camera, but if you go in person in a courtroom, that's what you do. I have even taken a statute and put it on 8.5 by 14-inch paper at like the biggest font I could do, like 48 font. And I'm like, Your Honor, Civil Code 845 about on the obligation to make repairs of an easement says this. It has the word repair. It doesn't say improve. That's to our next case. So, I do that. It's not, it's good. It's part of communication. All right.
Well, Michael, that goes to my comment about our first case, which is when I was able to see a picture of the property, I could understand what was trying to be conveyed and what was done here, right? And so you're saying the same thing, right? Whether you're talking to
Yeah.
a judge or whether you're talking to a jury, it helps them comprehend if they could see as opposed to only hearing. And some people learn visually, some people learn audioly, and some people learn both ways. So why limit yourself? Take every advantage that you can. Michael, you got 2 minutes to finish up
All
here
right.
because we got two other cases.
Okay. So look, when you do a trial or any hearing, it's boring. It's boring. You got to like do what Neil just said. Show pictures. In your pleadings, put diagrams, put photos. You can use, make it, if there's a PDF, you can highlight, copy and paste a section in there. Neil, could you scroll down a little bit on your Sipkin Secrets page?
Well, it just goes to the next
Okay.
slide.
Anyway, I'm just saying you can also use cheat sheets even for your normal argument. Okay. When I do a trial, I think I know evidentiary objections pretty well, but guess what? I have a 1 page, and I got another one's like 4 pages, but I have it with me because sometimes every so often you're gonna just say, now, which evidence code is that? Okay, so I'm gonna have it ready. Okay, I've always been like that. I have my cheat sheets ready for things. Just always done that. If you can go down to number 9. Um, the biggest thing I just want to stress, I said in the beginning, no ad hominem attacks. Okay, it's distracting. You're not making the point of the case. You're not arguing it's a code section or a legal issue. People do it all the time. They want to say, Mr. Simpkin is so whatever, or that client. No, just don't do that stuff. Okay, it's really important. And the other thing, it's really important. This is just, I'm just going to say it out there. I've seen it. I've even been occasionally guilty of it. It's this mansplaining thing, and it's really offensive. This is, you got to be really careful if you're trying to explain to a younger lawyer or someone that maybe they don't do that area of law. You just, everyone knows something more than you do. Keep that in mind. You may think you're like, the best thing since sliced bread or whatever, but I guarantee you, even the lawyer that you think is not competent, he's competent in something. Okay. Anyway,
And so Michael, we're not gonna go through all these other things. You already talked about being honest and truthful, be focused. And I think what you're saying is a little humility probably goes a long way, even when you're in court.
that's right.
All right. So let's get going. We're gonna got two more cases. We're gonna whip through these two cases. The first one is Ohio House versus Costa Mesa. Excuse me. And this is a case about a sober living facility. You had Costa Mesa that set a rule in this particular zone, and it said for this zone, you cannot have a sober facility within 650 feet of another sober living facility. And the sober facility, one of the sober facilities that was there, had to apply for their permit and was denied and challenged. And they challenged it basically on unfair housing and discrimination grounds. You see here the trial court found in favor of the city. The Ohio House appealed. Interesting kind of factual scenario here is that there were 4 facilities within the same distance. One of them had previously applied for and received their permit first before Ohio House. And then 2 of them were kind of outside of this provision because they are not really private facilities. So, kind of interesting fact here. Then we went to the appellate court, and the appellate court said, well, let's look at the Fair Housing Act. And yes, you cannot deny housing because of certain factors, protected classes, right? For example, or protected categories. And the court said, well, wait a minute, there really wasn't a denial here. What happened was there was an exception allowing these uses. And the court said, yes, it's true. The exception could have been greater and could have said, well, we're going to allow this exception anywhere within the zoning district, but the city said, well, what we're going to do is we're going to place some restrictions. So where we could have said none, we're saying, yes, you can have some, but there's going to be a distance restriction. And the court said, well, what's happening here is that a a use that maybe wouldn't have been allowed is being allowed. So the court said, that's not discrimination. That's not what's going on here. There's kind of an interesting side here about testimony from government employees who said, well, the intent here really was to discriminate. Okay. And the court said, well, those employee statements, they're not determinative. The jury could have reached a different conclusion based on the facts of this case. You look at my last sentence here, if you're able to see it, it's down at the bottom. Um, this was an appellate opinion, right? So it's a three-judge panel. There were four opinions in this case. There was the main three justices, four opinions. There was a main opinion. There was two concurrences, okay, and there was a partial dissent. So a lot to read through if you're interested in fair housing and you're interested in these rules.
All right,
Michael?
so Neil, here's my brief comment about that case. What city was involved and what location? And I know this is something realtors learn a lot. Was it the acronym NIMBY, not in my backyard? Isn't that what
Right.
this case really is about? They didn't want sober living facilities there. That's the bottom line.
Well, but they were allowing them, but to a limited degree, I guess. But when you're talking about where this case is, right, Costa Mesa, so you're talking about Orange County, California, and there's a lot of cases that are going on now where certain jurisdictions in Orange County are fighting back against the government mandates for things like low-income housing, right? And so trying to preserve the neighborhoods essentially as they were before the state mandates. I said government mandates, the state mandates. So you're right. Those things all need to be taken into consideration. Let's quickly go through our last case of the day here, Michael. And we got the Schneider versus Lane case where there was a access easement to a property. The easement ran along the Trinity River. The Trinity River flooded, ruined the access easement at one point in the past. So the owner said, "Okay, we will allow the access easement to be moved further inland." Lo and behold, there was another flood, ruined the easement that was moved further inland. And I guess the owner said, "Hey, listen, I'm not just going to allow this easement to keep moving and moving and moving further in along my property. That's not right." Okay, the serving tenement right holder said that's not right. You just can't keep moving your easement inland every time the property floods. What you're going to have to do, dominant tenant holder, you're going to have to, basically build a seawall or a river wall to protect your easement. And the dominant tenant holder said, "Well, wait a minute, why would I have to do that?" And then this is the case. It was a mostly unpublished decision. So when you're reading, be careful, and you're citing, make sure you're citing to a published part of this case, because about half of it, I think more than half of it, is unpublished. And they look at Civil Code Section 845. The owner of an easement shall maintain it in repair. This was what Michael was talking about, really highlighting for the judge or the jury what the relevant language was. And well, what do you have to maintain? And the court said, well, we're looking at two things. The land to which the easement attaches means the serving tenant, not adjoining land. And what does maintain mean? Maintain means to upkeep. It does not mean to replace. It does not mean to protect. It means to upkeep. And I, gave what I thought might be some good examples. Maybe you paint a surface. Maybe you fix a pothole, but you do not necessarily have to rebuild an entire easement. You do not necessarily have to build a wall to protect your easement, right? What is a capital improvement, I guess, to use accounting terms, versus what might be a yearly expense? Michael, what was your thoughts on that?
Okay, so I've used this section before. I've had these cases with private roads and the easement, and they fight over who has to resurface it and the asphalt, stuff like that. And I agree, it's the repair. The other practice pointer I'll give, I see this over and over. Um, I don't know if I should say this, but I have an expression. I don't care. What do I care? Pigs get fat, hogs get slaughtered. I see this all the time. Don't ever ask the judge for too much. Be reasonable. Okay. I think that this improvement that they wanted to the riverbank, $1 million or whatever they wanted, way too much, okay? And that's why they had the lawsuit filed probably, and that's why the courts said, repair, not spend $1 million or whatever to improve something. And I like your quote too at the end.
Right, because the quote had to do with, remember there was an earlier flood and there was a contest about whether the easement should be moved forward. And in the earlier decision, the dominant tenant was allowed to move their easement, and that wasn't challenged. And then the court here, one can think, well, maybe that was an incorrect decision. And this court said, well, that may have been an incorrect decision, but guess what? You got to live with what you got, and you didn't
Yep.
challenge it at the time. So we're just going to say, hey, you're collaterally estopped to challenge what was previously agreed to. Okay, wow, we covered a lot of stuff. Let's quickly go over our announcements because we got some announcements to make today. I want to make sure that all of you are aware of what's going on at the real property section. Again, if you've got an idea for an article, long article, short article, we're giving you the contacts. I thought I'd let you know what's going to be coming up for our real property law journal. So that's basically our law review type journal, right? Long articles, 100 citations, probably 20, 25, 30 pages, something like that. And what's going to be coming up when our first issue comes out, I think in 2 months, Let My People Go. I love the title. A proposal to update and reform California partition law. Second major article, an introduction to demystifying California coastal law. And I love this third one, Save Me Out at the Ball Game. Is being a baseball fan a contact sport? Love this. I know we had some cases we talked about before, Michael, where someone was injured by a baseball. Home run balls, abandoned property, and violence in the stadium. So some good stuff to look forward to in the RPLS Law Journal. Coming up, we've got a webinar coming up really soon, April 2nd, effectively using expert witnesses. And so if you check, perfect, thank you, Brooke is ahead of me. If you check the chat, you will see that Brooke has posted the link to sign up for the April 2nd webinar. Uh, Thought you might be interested, CLA's, California Lawyers Association Legislative Day. So that's not something that's unique to real property. It's for all the sections. It's for all California lawyers. If you want to know how legislation works, you might want to show up to the CLA Legislative Day. Thank you again, Brooke, for posting the link to that. Just for those of you who are thinking ahead, RPLS just had its retreat. It was in Monterey. It was a fabulous retreat. Hopefully, some of you were there. But if you'd like to go to the broader CLA wide meeting, well, that's coming up in September at Universal City. And now the application process is still open to become part of the executive committee. So Michael and I say, join us, become part of the RPLS executive committee. Maybe you'll replace one of the two of us on What's Up with Us, and you'll have a chance to speak to all 4,000 real property section members throughout the state instead of seeing our mugs up here every month. So that could be you. So send in an application. Um, and then let's see, Brooke, if you could post the link for executive committee applications. And I wanted to point out to you that we do have something new in the real property section. We have what we call practice area committees, which are smaller groups. So there's a dispute resolution group, there's a real estate brokerage group, there's a commercial property group, there's a finance group, and we're just starting a new one for international property. So if that interests you, contact Jose Mendoza at cbhome.com and let him know that you're interested in joining the International Practice Area Committee at the Real Property Law section. Oh, thank you, Brooke. Brooke just put up the appointment link. So we got a minute so you could look, you can copy or paste that or put it put it into your own browser and so hopefully we can get some applications and maybe you will be selected to join us. Lori raised your hand. Michael asked Lori if you could write your question. I do not know how to unmute you, Lori. So we're got 1 minute. If Brooke knows how to do that, great. If not, we're gonna have to ask Lori to write in your question into the chat tab. And while I am while I'm just going on for some more time, remember next month we're gonna have a giveaway of 1 hour of MCLE in the recorded sessions. So not one of the live MCLEs, but one of those you can go into the CLA library, go into the real property section, and next month we're going to give away a code so you can get 1 free hour of an MCLE of your choosing.
So we're paying you to
Okay,
watch.
Michael.
We're paying you guys to watch us next month. So make sure you tune in.
Yeah, we're paying you guys to watch us. Right. I like the way you think about that, Michael. That's really good. We're going to pay you to watch us. I guess that's what it's come down to. We have to pay you. We have to pay you to get an audience. So, but why not? If you're going to come anyway, take advantage. Maybe you'll be the lucky one. Maybe you'll get a free hour and then you could see there's actually a lot of good stuff in the MCLE library in the real property section for the CLA library. Michael, I don't see anything else in our chat tab. I'm going to say goodbye and I'm going to let you close us out.
All right. Well, thanks for tuning in, listening to my rambling. I have to work on this lighting. It's just getting irritating, like you said. But anyway,
So
please.
something to look forward to. Next month, you may actually be able to see what Michael looks
I don't
like.
know. I'm in my office. It's so weird. Anyway, but guys, really, the real property law section. If you think we're fun, well, yeah, we're probably the most fun. But you get a lot out of it. You should, you know, try to join us. Not just watching webinars, but you can come to one of the live events, one of the live, anything. You're gonna really like it. You're gonna build your business. Send in an e-news article. It's also good for your business. Thank you very much.
Bye, everybody. Thank you. See
All
you
right.
next month, April
Bye.
17th.
Okay, bye.